what
I
we'll
want to
see.
get to ghost guns. Before that, I just want to ask, how come no one's talking about Inherit the Wind? I mean, isn't this Inherit the Wind, the Scopes monkey trial, right? I mean, didn't Spencer Tracy already do that? I thought he did that. I saw the movie. It's excellent, by the way. And I learned from movies that the school can teach creation. I mean, they can teach science, evolution. They can teach about Darwin. And the town doesn't get to decide that their understanding of the Old Testament governs the science in the classroom. All right, Bill, I know you want to talk about ghost guns. Ghost guns are interesting because it's got a great name, because it's a kit. You know, there's statute that the government can regulate guns. The question is, what is a gun? Well, what if the gun shows up a la carte in a kit, various pieces, every single piece, and you, like a model airplane person, puts one together, and you put a bullet in, it works. And that's a ghost gun. And yes, so let me tell you something about those ghost guns. They have no serial numbers. There are no background checks to get anything like that. You could just put it together. And so the question became, well, these guns are being used in violent crimes. And so should they be treated separate from other firearms because they're actually split up into pieces rather than coming in whole?
So, first of all, this is, I think, my favorite decision of the past term because it's one I agree with. And so, just in terms of Supreme Court doctrine, so when I was in law school, when you were trying to understand a statute, you looked at the legislative history. You know, what did people say they meant by it? So this statute was passed right after Bobby Kennedy was shot. And it said, you know, no weapons unless you have serial numbers and do background checks. So if you looked at the legislative history, I think it's pretty clear that when you've got a new technology, I mean, they didn't have ghost guns in 1968. It's since then. But if you'd asked people in 1968 and said, look, there's going to be a new technology where you can put together guns in pieces, is that a weapon? They would have said yes, right? But that's not the way, really, because of Scalia, we look at statutory construction. We don't look at what they said they meant. We look at what the words are, okay? So the word is weapon, right? And is a gun kit, is a gun that you have to put together a weapon? And the Supreme Court, I think this is fascinating because Thomas in dissent says, a gun's a gun. If you have to put it together, it's not yet a gun. That's the way we understand the word gun. So it's not a weapon. Gorsuch, who's the biggest textualist on the court, this is actually a Georgetown brief that he follows, says, by linguists at Georgetown, say, we have a concept of artifact nouns. And that becomes decisive in the case. What's an artifact noun? So there's some things that are just what they are, an egg or a dog. Artifact nouns are things that you put together. And in linguistics, that can either be, it's not that word until it's done, or the pieces count as the finished thing. So for example, and this is, Gorsuch uses this in his opinion, the majority opinion. I go to IKEA and I want to buy a table, right? And I come home and my wife Allison is here and she says to me, what did you buy at IKEA? I will not say I bought table parts. I will say I bought a table, right? And so that's actually, that's the...
Does Gorsuch use that actually?
He uses that, he doesn't mention Allison.
Yeah.
But it was, you know, it was teed up at oral argument because Justice Alito asks the brilliant Solicitor General Elizabeth Perloger. He says to her, if I have some eggs on the counter and some onions and some peppers and some cheese, do I have an omelet? And she says, no, but that's because you can use those for other things. Imagine that you had a meal kit that you'd ordered, you know, where every one of those ingredients was all directed towards one thing. Then you do actually have that underlying product.
Right, because the pieces themselves have no other purpose other than as one thing.
So again, you know, it's interesting because the studies are, there's some times where the parts are not, for most people, used as the whole. So bicycle parts, you don't think of as a bicycle. On the other hand, If I'm writing a novel and I say, Neil, I'd like you to read my novel, and I've only got 3 chapters, that's still, you would say he's reading my novel, even though it's not done. So the linguists say, most people say weapon parts are a weapon. Like most people would say table parts are a table. And that becomes the key to the decision, which is remarkable. The idea that the concept of artifact nouns is deciding a Supreme Court case is stunning.
Cool.
And cool.
And it was cool that we got Allison in there. We always get Allison in there. We always, either I do it or he does it. Neil, TikTok. There was a case this year, the TikTok case. You may remember Congress passed a statute that said, everyone's using TikTok. It's not owned by China, but it's almost owned by China. They have an incredible amount of control. There are enemies, number one. Number two, they collect data. It's not a good idea to have TikTok be owned by China. Sell yourself or leave, right? Now, Donald Trump stopped and, well, let's not get so carried away. I like TikTok. Let's try to find another buyer. But there was a deadline, right? And the challenge was to say, hey, you're supposed to go out of business. TikTok said, well, don't we have a First Amendment right? And importantly, not just TikTok, but the people that use TikTok said, hey, don't we have, I sell my stuff through TikTok. What are you doing? You can't shut this down in the modern era. This is how I live my life. So it became a First Amendment question on a company with sort of creepy connections to a communist regime, but yet was able to seek the protection of the First Amendment. And then I think you've argued these cases before, it does seem in post 9/11, because you handled Hamden, if you say the word national security in our country in front of a federal court, especially in the Supreme Court, you kind of win, right? It does seem you mostly win. And in this case, the court said, hey, this is a question of national security, and it's more important than the First Amendment rights of someone dancing with their cat.
Yeah, you certainly, I do think that you win often in national security cases, but not always, and Hamdan is a perfect example in which the court struck down the Guantanamo tribunals, even though the president said it was necessary for national security. So in the TikTok case, Congress passes this law because of this Chinese connection, Chinese CCP connection with TikTok, and says on January 19th, you've got to either divest control China or cease operations. And of course, nothing happens. And so instead they file a lawsuit. And on January 17th, 2 days before the law was to go into effect, you have the Supreme Court issuing this decision that basically says that TikTok, they reject this idea that TikTok has a First Amendment challenge. It says the law is, because of national security, constitutional and can go into effect. Donald Trump, as president-elect, filed a brief in that case, and the brief literally said Donald Trump is the best negotiator ever, and as a result, nobody can negotiate like him, and as a result, the court should just wait until January 20th. The court doesn't wait. They issue its decision saying that the TikTok ban should go into effect. Now, Congress, when they wrote the law, said that, that there was a one-time exception that the president could make. And if he made certain certified findings for one time for 90 days, the suspension of TikTok could be put on hold. So what does President Trump do on January 20th? He suspends it for 90 days, no certification, and then he suspends it for another 90 days and another 90 days because he has difficulty reading what a one-time exception means. And that's where we are right now. And this is a very dangerous constitutional thing because, and we now know this from Freedom of Information requests that came out last week. Basically, the law didn't just prohibit TikTok from operating. It prohibited any service provider from aiding TikTok. So every time Apple installs the application on your phone, that violates the TikTok statute, or Google on their phone system and the like. So billions and billions of dollars in damages are potentially there. What did the Trump administration do? They wrote some secret letters to these different tech companies and said, don't worry, what you're doing is not illegal. Now, that is not something I've seen happen to my knowledge, in our lifetimes. We've certainly had examples of the executive branch doing stuff that's outside the law, but here what you have is an executive licensing illegality by third parties and saying don't worry, I'm not going to enforce it against you. And if you think back to like the English Declaration of Rights of 1689, one of the complaints about the king is that he had the pretended power to suspend the laws and the execution of the laws. There's a reason why Article 2 of our Constitution says the president shall, quote, take care that the law be faithfully executed. It's a direct result of that 1689 history. And what you have now is a president saying in secret to his friends, don't worry, I'm not going to enforce the law against you. I can't think of something that could be more dangerous.
All right.